So good afternoon or good morning to you all, and thank you so much for joining today's webinar, where we'll be discussing hopefully everything you need to know about 13f-2. And I think the timing of the webinar today means that it will hopefully be a very interesting and up-to-date current discussion, given the very recent inauguration of President Trump and all the changes that we might expect to see coming out of the SEC as a result of that. So just to kick off with a few housekeeping points first, this webinar is being recorded and details of how to access that will be sent to all the attendees after the event. We've also had numerous questions that attendees have submitted in advance, which has been great, which we will aim to cover in the main content of the webinar. But also please do use the Q&A function that's available to submit any other questions that you may have, and we will attempt to deal with those that kind of have the most sort of generic nature and appeal to the audience today at the very end of the webinar session. So all that's left now for me to do as a sort of start off is to introduce Wallace DeWitt, who is joining us today. He is counsel with the US Financial Services Regulatory Practice of A&O Shearman, and he represents foreign and domestic financial institutions as to a variety of securities regulatory matters, but with a particular focus on the private wealth industry and the cross-border marketing of investment services and financial products. He also, kind of most importantly from our perspective, aosphere is our outside counsel in relation to various US shareholder disclosure regimes, including both Form 13F and, of course, the new Section 13F-2 rules. Last year, he also, very importantly, filed an amicus brief on behalf of the Committee of Capital Markets Regulation, challenging the SEC's administrative procedures in adopting the short selling disclosure rules and the new Form SHO. He also formally served as senior counsel to the acting chairman and Commissioner Michael S. Pilwell of the US Securities and Exchange Commission. So thank you so much for giving up your time, Wallace, to join us today on this webinar.
Well, thank you very much, Fiona, for having me. And I'd like to return the favor. Fiona O'Shea is a senior lawyer at aosphere, one of the expert legal minds behind its Rulefinder Shareholding Disclosure product, which most of you know, and has been developing it for over 15 years at this point, I think. The product is aosphere's market-leading legal analysis tool for shareholding disclosure rules around the globe, including the United States, where I have a part in producing the material with some of my colleagues here in Washington and New York. Fiona's particular expertise, it's claimed to be European shareholding disclosure, but I can tell you from personal experience, she's as well versed in US law as one can be without being licensed and practicing here. And I've been working with Fiona. So I've been working closely with Fiona for a number of years as part of our regulatory counsel team for the US content, and Fiona and I follow developments very closely, including up to the minute. On my other screen here, we expect potential developments with 13f-2 potentially imminently. And I would say, just in closing, Fiona's previous experience as an M&A transactional lawyer with legacy Allen & Overy, now A&O Shearman, where I work, means that she has the commercial background that I think aosphere products are well known for. So thanks again for having me, to aosphere and to Fiona.
Thank you so much, Wallace. Yes, indeed. I think we've both been refreshing the SEC website kind of on a 5-minute basis with this upcoming webinar. So with that, let's get kick-started and take a look at the agenda that we intend to cover today, because we've got a lot of very topical issues to get through. So first of all, we will spend just literally a couple of minutes of just reminding us of an overview of what the 13f-2 new requirements are, and then get really into the meat of some of those tricky areas. So the status of the pending court challenge of 13f-2 and the share lending rule in the Fifth Circuit, and then the challenge that we're all grappling with at the moment of how to deal with reporting of shorts of foreign securities. And then sort of some of the more topical issues of the effect of recent changes that we've had in the US for both long and short position rules. And then the topic that I have to admit I'm personally very interested to hear kind of Wallace's views and thoughts on is the anticipated regulatory landscape under the Trump administration and the incoming SEC. So let's set the scene first and spend those few minutes just reminding ourselves of what the new 13f-2 requirements are. Basically just cover off the key questions of when, who, and what are we needing to think about reporting. So when does the reporting requirement commence? Well, it actually has started already as per the 2nd of January, but we've got the Valentine's Day as being the day that the first reports need to be filed with the SEC. However, with all the changes that we've got happening in the SEC at the moment, there is possibly potential for the SEC to extend the first filing date, or depending on the results of the court case, that could happen, but much more detail about that a little bit later. Who needs to report? Well, it's institutional investment managers with investment discretion. Those will be the same managers who report long positions in 13F reports. It's a very broad definition and will include non-US institutional investment managers. All of those managers, however, do need to have the investment discretion, but again, that definition being very wide and drawn again from 13F reporting. What securities need to be reported? Well, 13F-2 is very focused just on equity securities. However, life's never kind of easy in these kind of types of regulation. So it is wide. It's not just straightforward shares, but various different types of security instruments that give you the right to physically acquire those court equity shares. So some of the types of instruments that would be in scope are listed there on the slide. I think one to remember is that pure debt instruments or cash settled security, though, is outside of scope. The identification of what types of securities are in scope, we're very aware is a challenge, because unlike 13F reporting, we don't get a nice list from the SEC of the in-scope securities that are covered. The rules do specify the thresholds at which short positions in the court securities need to be reported. And the key issue here is that there are two different thresholds. For reporting company issuers, you've got the $10 million threshold or the 2.5% of outstanding shares. But then you've also got that lower threshold for non-reporting company issuers of just the $500,000 threshold. So that, of course, leads you on to the obvious question then of what is a reporting company issuer for the purposes of these rules. It would include all of the equity securities listed on the New York Stock Exchange or NASDAQ. Again, not as straightforward because it is wider than just those securities on those exchanges. And again, as I said, there's no SEC list that would be setting those all out for you. So that's a quick snapshot of what the rules are that everyone's kind of focused on. So let's look at the court challenge in a bit more detail. So I think it's fair to say, isn't it, Wallace, that it's not been the most well-received piece of regulation, despite the market knowing that there was some kind of short selling regulation that was coming down the track, kind of out of the statutory authority from Dodd-Frank. And I think it probably stemmed from, there was a lot of lead-in time, a lot of consultation, a lot of effort put into responding to that, and then a bit of disappointment and probably frustration as well, that a lot of the issues that were very practical that were raised didn't appear to be listened to in the kind of final regulations that came out, and there was a bit of lack of clarity. Also, there was a bit of sense that perhaps it was sort of pegged together and rushed through because it was approved, within minutes of the share lending rule. And I think that was the background probably that then set up that court challenge of the National Association of Pension Funds. So the oral hearing, I think it was October. I was about to say November, but it was even further back. It was October. I assume there's not been any update, but do you want to just run us through what the basis of that challenge was to kind of set the scene for us?
Certainly, and thanks for that introduction, Fiona. You're tempting me to unload my true feelings on the SEC. So I should probably append my disclaimer that my views are my own and do not reflect those of the partners for whom I work at A&O Shearman necessarily.
Understood, Wallace, but higher
Or
way.
my clients at aosphere.
Yeah.
So as Fiona alluded, a trade group styled as the National Association of Private Fund Managers filed a petition in U.S. federal court on December 14th, 2023. Specifically, they filed it in the U.S. Circuit Court of Appeals for the Fifth Circuit. I think the courthouse is in Dallas, Texas. It covers some neighboring states like Louisiana, maybe perhaps Arkansas. I forget the precise geographic area. Just from right off the bat, to observe for those of you who are not U.S. citizens or familiar with the U.S. legal system, that is a clear-cut case of forum shopping. You might expect a case like that to be brought in the D.C. Circuit, which is where I clerked. It's considered the Supreme Court of Administrative Law, or maybe the Second Circuit, which covers New York and environs for obvious reasons. This was brought in the Fifth Circuit, likely because petitioners viewed that as a more favorable circuit in terms of the composition of the judges as a substantive matter. We'll get into that in a minute. So the petitioners challenged the SEC's issuance of twinned new rules covering share lending and short sale disclosure. Today, we're talking primarily about 13f-2. I will tell you that another set of my clients, particularly my amicus brief client, the Committee on Capital Markets Regulation, was much more fussed about the share lending rule than about 13f-2, but they're both being challenged simultaneously by petitioners. The petitioners contend that these closely related rules, and I'm quoting here, present a particularly stark example of arbitrary and capricious agency rulemaking in violation of the Administrative Procedure Act. In addition to asserting that the SEC's rulemaking ignored material public comments, a requirement imposed by the APA, which is a quasi-constitutional statute from 1947 that sort of attempts to regularize the independent agency model, which doesn't fit within the founder's vision, or at least that's the perception, right? So they argue that it violates the APA by ignoring public commentary. It also, petitioners argue that the SEC's disregard for the interrelationship of the share lending rule and the short selling rule and their respective costs and benefits warrant a vacatur, a vacation, and remand of the two rules by the court to the SEC. As Fiona alluded earlier, I served as counsel to the Committee on Capital Markets Regulation in connection with this case and filed a friend of the court amicus curiae brief in support of petitioners, arguing that the cost-benefit analysis conducted on both rules was faulty and contravened the SEC's separate statutory obligation under the Securities Exchange Act of 1934, as subsequently amended, their obligation to assess the costs and benefits of its rules and at least establish an argument that the benefits exceed the costs. As Fiona said, the case was argued in October. Both Fiona and I studied the oral arguments carefully. And I don't want to speak for Fiona, but I don't think any of us came away with any certainty as how the panel is likely to rule. For your reference, and this appreciating that this is a little bit dirty politics, but it should be said. The three-judge panel featured one Trump-appointed circuit court judge, one Trump-appointed federal district court judge on loan to the appellate court. That's a trial court judge from New Orleans on loan to the circuit court to fill an absence, and one Obama-appointed circuit court judge. That's a 2-to-1, facially a 2-to-1 Republican majority, which you can draw conclusions on that basis. My personal impression was that all three judges probed both sides equally and exhaustively. There might be a hint of suspicion of the SEC's position in the argument, but as Fiona said, as of this date, the court's opinion has not yet been issued. It's difficult to handicap the outcome of any litigation in the states. There's been a lot of shifting, as you might have heard, in our Chevron doctrine and the major questions doctrine. There's a lot of changes in our administrative law underway at the Supreme Court level and certainly in the new administration. The Fifth Circuit does not have extensive precedent in securities law or administrative law. Texas would have strong, law regarding oil wildcatting and things. This is not an industry that's typically been a focus in Dallas. But in recent months and years, this particular case forms part of a pattern in which private litigants are bringing cases to the Fifth Circuit to challenge, quite often successfully, SEC rulemakings under the Gensler SEC, which were perceived with some skepticism by the court.
So that was where the private fund.
The private funds rule has gone down.
Yeah.
There are others. The dealer rule was shot down in the Texas District Court. Now, I will say that there is a general expectation here in DC, where I sit, that the first reporting deadline of February 14th may be extended, either by the ruling of the court, which is imminently expected, or by action of the acting chairman and commissioners of the new SEC in office. As of this presentation, I mean, like 19 minutes ago, Fiona and I had not seen anything to that effect yet.
Yeah. And what are the various different options that the court can go down, just for sort of the non-US lawyer audience?
Sure. So one could imagine multiple dispositions of the case. On one end, the court could uphold both rules as issued by the SEC and rule for the SEC and against petitioners. That's possible. The court could do what the petitioners requested, which is to vacate both rules, meaning that they are simply eliminated, and then remand to the SEC for further proceedings. As we'll come to a little bit when we talk about the rule in more detail, this rule 13f-2 is mandated under the Dodd-Frank Act. So there is a constitutional statutory authority and mandate granted to the SEC to come up with a short selling rule. It need not look exactly like this one. That's one of the questions in dispute. But the SEC will eventually have a short selling disclosure regime unless repealed by Congress. In between those two extremes of upholding the SEC on one hand or finding for petitioners, one could imagine other intermediate steps. One of those might be to uphold 13f-2 if the court thinks it's close enough to what Congress demanded to leave it in place, or the court could say, we're going to remand the share lending rule for further proceedings, because that was largely, as I said, the focus of many of the complainants. Other options in between, I mean, the court has some authority here. If I were sitting in the case, I might say, look, even if I think that 13f-2 passes muster, I might say that both are remanded because the rules are so closely linked that it makes sense to give the SEC another crack at combining the two rules and coming up with a coherent system that covers both share lending and short selling. So could be any of that. You go to Ladbrokes and bet on it in London, no doubt at this point. But no one really knows here in DC.
And I guess also, sort of in my mind, I was kind of thinking, it's been a while since the hearing. If they were minded to kind of just dismiss strike the whole rule down, they knew that the compliance date was the 2nd of January. So kind of you would have thought that they might have got to hurry on issuing the decision.
That is a plausible construction of the silence of the court. Another one would be that if there is a majority for overturning it, the dissenter could also be dragging his or her feet about turning in the dissent. Or it might be that Christmas and New Year's intervened and they just haven't gotten to it because they've got a bunch of it's hard to read into silence, but yes, that is a plausible reading. And the court is certainly aware of the January 2nd effectiveness date and the February 14th first date.
So before we go on, Wallace, to talk about the tricky foreign securities point, should we do a little bit of betting ourselves? I think we've got a poll that we were going to sort of break up the webinar with. So it should be coming up on your screens now, our first poll question. So we thought we'd kind of, just see what the audience views are as to what might be the outcome. So either the question, do you think the court will, 1, vacate 13f-2 in its entirety, 2, vacate 13f-2 in part, e.g. the tricky non-reporting issuer threshold, or 3, uphold 13f-2 and dismiss the challenge? So it's all anonymous, kind of just a little bit of light relief if you could put your votes through, and we'll see if there's any kind of consensus of views of which way people think the outcome might go. So that's probably enough time for you to have done your vote. So let's see where we've come out. Overwhelming is number 2 by the looks of it, Wallace, which is vacating 13f-2 in part, e.g. the non-reporting issuer threshold, which I think probably leads us nicely on to the tricky foreign securities kind of section, doesn't it? Because I think that's what everyone's kind of hoping, is to get rid of that section of the rules which are proving so problematic.
Yep, so I'm happy to dive right into that, Fiona. So this is so there's been a lot of confusion over this, and having reviewed the questions submitted by the attendees today, I would say probably half or 3/4 of them addressed the question of how are foreign securities covered under 13f-2. In my opinion, and this is my personal opinion, having worked at the SEC in a political capacity before, the SEC courted this confusion through sloppy drafting and probably an overweening desire to protect its own bureaucratic turf. Many of you asked for a discussion of this topic, and so please just grab some coffee or tea and settle in for a fairly technical discussion of US administrative and constitutional law. So on the day on which both the share lending and 13f-2 rules were adopted, the 2 Republican commissioners, Mark Ueda, who is currently the acting chairman of the SEC, and Hester Peirce, who is famous for her comments on crypto and digital assets in general, both dissented from the adoption of the rule on multiple grounds. In her dissenting statement, Commissioner Peirce specifically posed the following question. Remember, this is on the day that the rules were voted on 3-2 to be implemented by the SEC. Commissioner Peirce asked, will managers have to report with respect to foreign equity securities and foreign issuers, even though such issuers have limited US jurisdictional ties and in many cases are subject to short sale reporting regulations in their home jurisdictions? If so, why? Now, Commissioner Peirce, whom I know quite well, is a very keen reader of SEC releases and is universally acknowledged as a leading figure in securities law. The fact that the very same question occurred to her as to many of you is strongly suggestive that there is something amiss with the proposed and final rule releases and the SEC staff's comments therein. So let's go a little bit deeper. In their brief, the petitioners challenging the rule in the Fifth Circuit made the following contention. I'm going to quote at length for the sake of precision throughout this presentation. Quote, the Commission likewise declined to make changes in response to commenters' concerns about whether the Commission's jurisdiction extended to equity securities not traded in the US. Per the petitioners, they continue, the Commission concluded that any institutional investment manager already subject to US reporting requirements would be required to comply with the new regulatory reporting obligation for both US and foreign securities traded on foreign exchanges. So that is the way petitioners characterize the SEC staff's conclusions in the SEC's final rule release. Now, petitioners' argument here is premised on a very famous 2010 holding of the Supreme Court in a case called Morrison versus National Australia Bank Limited, sometimes referred to as the foreign cubed case. This case is famous for setting the territorial boundaries of the SEC's authority and was handed down on a split basis by the Supreme Court during the early Obama administration. Petitioners characterize the holding of that case as follows. Under long-standing principles of American law, laws of Congress and agency regulations implementing them are meant to apply only within the territorial jurisdiction of the United States unless a contrary intent appears, namely a contrary intent of Congress. So let's go to the statute. Section 929X of the Dodd-Frank Act required the Commission to prescribe rules to make certain short sale data publicly available no less frequently than monthly. The SEC, in its final rule release, characterizes its statutory authority under 929X as follows. Quote, the Commission shall prescribe rules providing for public disclosure of the name of the issuer and the title, class, CUSIP number, aggregate amount of the number of short sales of each security, and any additional information determined by the SEC following the end of the reporting period. Now, as petitioners point out in their brief, and as I lingered over just there, a CUSIP number is, quote, assigned overwhelmingly to US securities. Yes, there are some foreign securities that have CUSIPs as well, but in the view of petitioners, this reference in the statutory text to CUSIP numbers is suggestive of a domestic focus, but at the very minimum, as Morrison would require, there is certainly no clear affirmative indication in the statute that evinces any congressional intent for this rule to apply to foreign securities trades. Now, at the proposed rule stage, several commenters in the notice and comment process questioned whether the SEC purported to apply 13f-2 to foreign securities traded on non-US exchanges. I would suspect that many of your companies you work for, and perhaps some of the trade groups in which you participate, were some of these commenters in the comment file. The SEC staff, to borrow words from petitioners, cryptically explained in a footnote that I bet most of you have read, explained that all of the rules reporting requirements, quote, apply to any institutional investment manager already subject to US reporting requirements. Now, taken at face value, this, in my humble opinion, very poorly drafted statement of the SEC staff, not necessarily known for precision in these matters, suggests that once a manager must comply with unspecified US reporting requirements for any aspect of its operations, the rule requires that manager to report all of its short sale activity around the globe, irrespective of where those trades occur or what securities are involved. And I'm paraphrasing a sentence from the petitioners with which I happen to agree. I found that insertion by the SEC staff to be puzzling. Now, I will pause for a moment, and apologies to anyone who doesn't love administrative law as much as we do here in the States. I want to pause for a moment and point out the very specific procedural posture of petitioners' argument here. Their core argument is that the SEC did not adequately respond to commenters, as the APA requires, and did not engage in an economic analysis of the application of the rule to foreign securities, as the Exchange Act would require. Further, implicit in their argument is that the rule as adopted is ultra vires. It exceeds the authority granted to the SEC under 929X, interpreted in light of Morrison's requirement that extraterritorial jurisdiction must be clearly and affirmatively indicated in the statutory text. That's complicated, but it's an important thing to keep in the back of your mind. We're challenging this, the petitioners are challenging this on grounds of administrative procedure faults, in addition to an implicit argument that the SEC exceeded its statutory authority. Now, having read the brief multiple times and having drafted briefs in response to it, the SEC's brief response, I think it's fair to say, was positively indignant at the suggestion that the SEC staff had purported to apply 13f-2 extraterritorially. So for the benefit of fairness, allow me to quote from the SEC's brief at length. Quote, and petitioners' suggestion that the Commission intends to apply the short sale rule to short sales of foreign securities traded on foreign exchanges is baseless. The rule applies only to managers that affect US short sale transactions in equity securities subject to regulation show, and thus is limited to domestic transactions. They continue, contrary to petitioners' contention, the short sale rule does not apply to short sale transactions of foreign securities affected outside the United States, which are not subject to the requirements of regulation show. So that might seem very straightforward. The SEC has now taken a position that the jurisdictional ambit of 13f-2 tracks that of regulation show, the 2005 rule that's been in existence for the better part of this century. That might seem straightforward, as does the following statement from the SEC's brief. Quote, just as regulation show does not apply to securities transactions affected outside the United States, neither does the short sale rule. But then look at the SEC's footnote to that statement, in which they state, petitioners assert that Section 13f-2, that is the statutory provision amended by Dodd-Frank, is focused only on domestic short sales. But this court need not address Section 13f-2's statutory reach, because the Commission's rule thereunder only applies to domestic short sale transactions. So what the SEC is doing here with some sleight of hand is saying that although Rule 13f-2 and form show by their terms only reach domestic short sale transactions, however defined, the court need not reach the question of whether Congress allowed for coverage of foreign short sales under the statutory text, presumably because the SEC wants to defend the maximal extent of its constitutional jurisdiction in all events. All right. As a coda to all of this, since I've alluded to regulation show, which is not at issue right now, but the SEC has specifically cited in defense of its new rule, I will quote from the SEC's FAQ, last updated in October 2015, almost a decade ago. Question 1.3, if you want to pull this up on your screens, how does regulation show apply to overseas transactions? The SEC's answer to this sheds some light. Quote, any broker-dealer using the United States jurisdictional means to effect short sales in securities traded in the United States are subject to regulation show, regardless of whether the broker-dealer is registered with the SEC or, as many of your institutions might be, relying on an exemption from registration like the chaperoning or broker-to-broker exemptions under 15A6. You know those. Short sale regulation applies to trades and reported securities when the trades are agreed to in the United States, even if the trades are booked overseas. Whether a short sale is executed or agreed to in the United States will depend upon the particular facts and circumstances of the transaction. So suffice it to say, this is a bit of a mess. The SEC has been talking out of both sides of its mouth. Petitioners probably overread some of the offhand comments of the SEC staff in the rule release to make hay with the court. The court hasn't spoken to it yet. The SEC hasn't granted any administrative relief, hasn't done any interpretive guidance yet. And then finally, they point us to regulation show, which says it's a facts and circumstances analysis of whether you're in or out of the United States. And all of your institutions, I presume, have existing policies and procedures about how to comply with the separate reg show in the States. I would consult those in the first instance. But I'm not comfortable on advising definitively one way or the other. I think that something is going to happen here. This is going to be probably delayed, whether by the court or the SEC. And I think an FAQ or a new rule will be forthcoming, because this is not an acceptable state of the law. So long story short, over to you, Fiona.
Yeah, I was going to say it's too much confusion, and there needs to be some clarity, doesn't it? And I did love your expression of, and I think everyone who read it in the SEC's response, it was like you phrased it as it was a bit indignant of the SEC saying, well, actually, no, we never intended for that kind of wide extraterritorial reach.
Yeah, I'm shocked to find gambling in this establishment. Yes, exactly.
So just picking up on the, there needs to be some clarity, some statement coming out of the SEC of what to do, particularly on this foreign securities point or from the court case. And actually, what I was just going to raise was we've seen a couple of letters very recently, just in the last week, from industry bodies such as A&O and the ICI, submitting letters to the SEC requesting relief from enforcement of action on 13f-2 until at least July at the earliest. Basically on sort of two grounds. One, on the sort of technical complications of kind of getting all the data in a correct form and submitted, but also on this foreign securities point. How common are those types of letters in getting a positive outcome from the SEC? I mean, I noticed there was one, in fact, only yesterday, similarly on Form PF, and I, as a non-US, I was like, oh, actually, that's kind of in the same kind of avenue. So, what do you expect to see?
So I can speak to this a bit. So I was, 8 years ago in a very similar position to where the SEC political staff finds itself. I was working for, as Fiona mentioned earlier, acting chairman PVAVAR in January of 2017, where rules like the Congo conflict minerals disclosure, pay ratio disclosure, all that from Dodd-Frank, were in some cases extended or enforcement postures were altered when the political winds changed in Washington and a new SEC came in. So it's not unheard of. Letters of that type from the major institutions. I will note that SIFMA also sent one of those in here in the States, not only the foreign trade groups, asking for some form of enforcement relief, not uncommon. It's an excellent time to do it right now. They're very busy and they're getting a lot of feedback and static from a lot of different rule sets. But to the extent that the attendees have a government affairs office and would like to pass these things along to the SEC directly, I would encourage you to send your thoughts. I think the SEC gets relatively fewer inputs from abroad, and but foreign broker dealers and investment managers are incredibly important to the U.S. securities markets and are major players in it. So I know that there's an appetite to hear from people. I would talk to your trade groups who represent you, your outside counsel, to the extent that they have contacts with the SEC. This is a time to be vocal and to suggest to the SEC what you like to see.
I think that's really helpful because obviously, yeah, we've only got just under 2 weeks. So yeah, putting in those letters to try and push it up the SEC agenda. So I think should we do another quick poll, Wallace?
Sure.
Which we just thought it's sometimes comforting to know what your peers are doing at other organisations, what other market participants are grappling with the same issue as yourself. So the next poll question that we had was just what is your intention with respect to short positions on a non-US market that are affected outside the US? So, if the status quo is as today on the 14th of February, kind of what are you planning to do? Are you going to include them in your 13f-2 filing, exclude them, or kind of, just be undecided right up to the day, hoping for some SEC FAQs or a statement of relief coming out? So yeah, if you could just put in your votes there, and so we can see kind of where the audience is lying in approach to this.
And while you're responding to the poll, I might mention in this connection an analogy to the enforcement footing of the SEC with respect to Form 13F, the CAPF, the long reporting form that's been long in use for decades at the SEC. And I would assume many of you dealing with 13F2 also wear a hat with respect to your long positions on 13F, where you're dealing with that a lot. Historically, the SEC on 13F has not nitpicked, and this is interesting, interesting. The SEC has traditionally not nitpicked the contents of a Form 13F for the contents. The historical enforcement actions in the 13F context have typically been for non-feasance. So there was a case in September of last year where 11 institutions, including foreign institutions, were charged in enforcement action for failing to file 13Fs at all, despite the fact they were subject to it. The other kind of cases are typically malfeasance. So there was a famous case in 2023 when the Church of Latter-day Saints, otherwise known as the Mormon Church here in the States, was enforced against for an alleged scheme to evade 13F by splitting up their holdings at different managers under the $100 million threshold that applies. Whether 13F and its history is a reasonable precedent for the SEC's enforcement footing when it comes to questions like, do we include or do we exclude foreign securities? Hard to say. This is a fresh rule coming into a green field. It would not surprise me if the SEC were relatively lenient with anyone who came with a bona fide and justifiable position as to why I treated this option or this derivative in this way as opposed to an alternative way, in the absence of direct guidance to the point. I'm strengthened in that conclusion by the fact that the incoming SEC is likely to disagree with the prior SEC on a great many matters, including how to enforce kind of a broken windows approach. So
Yeah.
anyway, but the responses here are interesting. So, it looks like a plurality for inclusion in 13F.
It is. I think, yeah, sort of act with slight caution, which I think is everyone with the history of the last kind of, administration under the SEC is probably understandable. People, want to act a bit more risk averse, perhaps.
Yeah, and that's, I certainly, the advice we've been giving for months, many clients have said, do we have to bother with this at all, given the status in the courts or the new SEC or whatever? I'm afraid that a conservative approach is the appropriate one. Plan for the worst, hope for the best.
Exactly. Remain optimistic. Okay. So I think if we just close that down. We're going to put 13f-2 to the side just for a brief minute, and just look at, obviously there's been a lot of recent big SEC changes that our audience kind of involved monitoring day to day, with both 13D and G overhaul. So I thought we'd just take a little pause to just see how those rules have bedded down. The sense we've got from our subscribers at aosphere is obviously those have been a lot less controversial, the shortening of the filing deadlines. But I know there's been a few interesting high-profile cases for enforcement recently, which we get quite excited about on the sort of beneficial.
I can think of one.
Side. Over to you, Wallace, that you might want to kind of mention.
Yeah.
On that front.
So as Fiona suggested, I don't think the 13D and G updates or what they call the modernization of these was as controversial. I can't recall the vote on the SEC, but I don't think it occasioned quite as much of an outcry. Largely this was reducing the filing deadline for 13D from 10 days to 5 days. For those of you maybe not familiar, these are the beneficial ownership rules that 13D is about control situations. It was introduced largely in the 60s under something called the Williams Act to deal with hostile takeovers in the United States. That was very actively policed in the 1980s when people like T. Boone Pickens were taking over RJR Nabisco and all the famous, Wall Street sort of shenanigans of the 80s. 13G is the one that large passive investors will commonly come across once they cross a particular threshold, but with no control intent and no desire to vote the securities to control the company, et cetera. They can file a somewhat less burdensome 13G. These rules also involved, they sort of codified existing SEC guidance about how to deal with cash settled derivatives. So in cases where a derivative has elements to it that allow for an exercise or indicia of control, they can be treated as though they were a grant of beneficial ownership, even though typically derivatives are not considered to be beneficial ownership. On the enforcement front on 13D, as Fiona was, I think, alluding, there was some interesting news on the eve of the departure of the prior SEC, I think shortly before the new year or shortly before the inauguration. I can't remember the date. But the SEC staff has launched an enforcement action against Elon Musk, head of SpaceX, Tesla, the Boring Company, and also the soi-disant Department of Government Efficiency, the DOGE, here in the States, alleging that he failed timely to file a beneficial ownership report on 13D after acquiring 5% or more of Twitter common stock. Of course, as everyone knows, a couple of years ago, Mr. Musk took private Twitter, which was formerly a public company. The SEC claims that Musk saved at least $150 million in his takeover at the expense of Twitter shareholders. Mr. Musk, for his part, and his lawyers, as I saw on Twitter, reacted to this with fury. I expect fully that they will challenge the SEC. It is the politics of this are mind-bending and difficult to imagine. So we will see. That is, for those who watch securities law as a diversion from football, this is something to watch for the coming year, I would say.
I think it'll be an interesting one to see how the political angle of that plays out as well. So I think that leads on nicely actually to our kind of last topic that we were going to cover, which is obviously the regulatory landscape and how we might see some quite sort of big changes actually under the Trump administration, which is not even a fortnight in actually. And so, yeah, I don't know which one you kind of want to deal with first, just aware we are sort of running a little bit short of time now. And so up to you, Wallace, which one?
Yeah, I can hit a few high level. I can hit a few high level points, and if anyone wants to come visit DC or give me a ring, or better yet, bring me to your jurisdiction for a pint or something, I'd be happy to talk about it. So essentially, under Republican administration, I think you will see a massive shift away from the way, particularly Chairman Gensler ran the SEC for the last 4 years. Chairman Gensler is an outlier even among Democratic chairmen, and has been severely criticized by a important faction of the Democratic Party and virtually universally from the American right or the Republican Party. I think there will be a dramatic curtailing of the speed, pace of the regulatory agenda, which was beyond even the Dodd-Frank era in his case, despite not having any congressional mandates for it. So I think that you will see a slowing down and a period of digestion of the rulemakings that have hit. I think you will see once former Commissioner Paul Atkins, who is going to be nominated by President Trump to run the SEC as the permanent chairman, once he is confirmed sometime this spring, speculation I've heard is March or April thereabouts. Once he is in, we have a full complement of SEC commissioners. I think you will see a deregulatory agenda. In part, I don't think that the Gensler agenda is going to be wiped clean. Deregulation in the states requires the same notice and comment and cost benefit analysis procedure.
Okay, so not a quick process then.
So it's not, you don't just tear these up with an executive order. These are independent agencies that have their own rules. They have a quasi legislative function, they have a quasi executive function, they have a quasi judicial function. They operate differently from what you might be reading in the news with the State Department or the Treasury or the Defense Department, which are more directly under the president's foot. With enforcement, it is not commonly the case, contrary to what a lot of the press sometimes says. Republican administrations tend not to reduce the amount of enforcement. They tend to focus it on different targets. So to draw very broad generalities here, the SEC staff or Democratic commissioners are generally more open to corporate penalties assessed against corporate violators of the securities laws. Republicans are generally speaking inclined to say that that punishes shareholders who have already been defrauded in the initial fraud. That's a broad discussion that's been going on for 80 years in the United States. Republican administrations tend to focus on individuals who are culpable for whatever violation of the securities laws has happened. Democratic administrations focus on individuals and entities. I would expect for those of you interested in crypto, I would obviously expect a sea change in the approach to crypto. I would hasten to add, however, that when I was at the SEC, I was there under Commissioner Pivovar in his personal office. Chairman Jay Clayton was running the SEC at the time. I would not say that there was a great deal of appetite for crypto, even among the Clayton administration at the SEC. That was obviously shared in spades by the Gensler administration of the SEC. I would speculate, based upon personal knowledge and of observing him over the years, I think Paul Atkins is more open to crypto and digital assets than either of his two predecessors on either side of the aisle. But what I would suggest to all of you, if you're following this closely and you're advising your various business teams, I would watch the Atkins confirmation hearings in the Senate when they're scheduled. It's light watch, probably an hour and a half. He'll be grilled by senators from both sides. He will expose some of his goals, his hopes, his aspirations. You'll see some of his agenda there. I think that's a good way to follow this, as well as just staying close to Fiona and the aosphere team, who are constantly pinging us for updates of what's going on the ground in DC.
Monitoring it all. And I think that's a really, really good tip. And I note with the crypto, that was one of, obviously with kind of me and you have been checking all the SEC press releases so up to date, but I did notice that one of the first announcements was putting up together the crypto task force. So that's obviously very high up on their agenda, isn't it? And just that very last point, just to briefly deal with it, because I know our audience do follow that a lot, just because they're tracking kind of any investment restrictions that their organisations need to comply with, and whether your thoughts are that any of that would change, because there was some new rules, I think, that only came into effect on the 2nd of January, so just before President Trump, which was very much restricting kind of outward bound investment and specifying just China as one of the concerned countries. So whether you thought there'd be any shift on those kind of issues.
Yeah, that's an interesting question. So this falls, to be clear, this falls outside of my remit within the firm. I'm a securities lawyer. This is more of what we call reverse CFIUS. We have here in DC a former official from OFAC, the Office of Foreign Assets Control, who is our partner who covers sanctions. So if this does come up in your business, I'm certainly happy to put you in touch with the experts. In June of last year, the Treasury Department issued a notice of proposed rulemaking that was subsequently finalized, as said, in November, shortly after the election. If you're familiar with CFIUS, this is the rule set of the Treasury Department that requires a review of inbound investment by foreign investors under certain circumstances, particularly when there's an intersection with U.S. national security, broadly understood. You may recall during the Bush administration, there was a proposal for the Dubai ports to purchase, I think, the port of Los Angeles or New York or something that was blocked under CFIUS or came into CFIUS review. This is sort of the flip side of that. So this rule would subject to further regulatory scrutiny outbound investments into so-called countries of concern. That's the People's Republic of China, so mainland China, Hong Kong, and Macau, the special administrative regions of China. And it would particularly focus on 3 sensitive technology industries: semiconductors and microelectronics, quantum computing, quantum information technologies, and artificial intelligence, all of which are constantly in the news. And particularly, I think part of this rule set sort of grew out of American and broadly Western concerns about the stability of our supply chains in these technologies during the COVID period. So there's currently, President Trump, I think earlier this week, has talked about potentially slapping tariffs on independent Taiwan with regard to microprocessors and things in a hope to develop more of a domestic industry there. It is very difficult to assess. I personally just simply am ignorant of the Treasury Department at this level. It is an executive department. It comes directly under the president's control. It's next door to the White House. You could throw a rock from the president's bedroom and hit it. I would expect that there is an alignment between the Republican and Democratic parties on a bipartisan basis to show skepticism toward China in these areas. As a political matter, I wouldn't. Certainly, the rhetoric on both sides is very strongly critical of mainland China. Whether this has legs and how they will enforce it is really a question for my expert colleagues.
Yeah, that's really helpful, interesting. Well, I think that kind of sort of wraps it up. So with the last kind of one to deal with is just the questions. So as we said at the beginning, there were a lot of questions submitted in advance, which hopefully they really helped us kind of plan the content that we wanted to cover today. Whilst I just look at the questions that might have been raised during the webinar, Wallace, do you want to just briefly recap then kind of where we are as of today,
Sure.
If there's no SEC statement on foreign securities? And I'm just going to have a quick look at the Q&A here.
Yeah, so I would say where we are today is we are waiting for the sword of Damocles to drop from the court or the SEC. Caution would say that you should continue full speed ahead to prepare your 13f-2 filings until told definitively otherwise by somebody with more authority than I have. I would say that if you are finding yourself irreducibly in a situation where you cannot figure out what the SEC is actually calling for and your outside counsel is not giving you advice that is definitive, I think take bona fide, reasonable basis conclusions about what the rule says, root them in what the SEC has said, both in its brief and in its final rule release, and move forward on that basis, and then continue to assess your reporting. This is not a once and done report. You're going to be doing this monthly hereafter, or whenever it begins, whenever it definitively begins. And you're not locked into one reporting strategy forever. You shouldn't willy-nilly change them. But you should take sensible positions that are responding to the SEC staff's latest and greatest administrative guidance. That's what any lawyer would tell you. And if you have questions on these, I have looked through some of the questions as well, Fiona. There's a lot of technical questions here. I would be disbarred if I answered half of these live without thinking about them. But happy to field whatever technical questions you might have. My email address is easily available on the internet. I could either me or I could direct you to lawyers at your firms. That will be helpful.
Yeah, I think that's. I was just having a quick skim too, and there's a lot of sort of very technical ones of kind of what we put in Form 1, what we put in Form 2, the tables. And we've obviously got an audit of all of these, so we can have a look at them with a bit more time to consider and get back with some kind of more detailed answers on those. There was a very sort of more general housekeeping kind of question that I saw raised about will we be sharing the recording or slides afterwards? And yes, we've got that all set up, so we will be able to distribute that. But also, if you just get in contact with aosphere, then we can send you a copy of that. So I think that kind of wraps us up, spot on the hour, Wallace. So there was a lot of, I think, really interesting stuff to get through, and we managed to kind of pull it all together. Just to, as a reassurance to all of our audience, as you've probably heard both myself and Wallace allude to on several occasions, we are avidly monitoring the SEC press release statements website, because we very much kind of expect, hoping there'll be some kind of extension announcement coming out. I think it was really helpful to, obviously, Wallace, you also kind of expressed that this is the time to put in any of those letters asking for relief from enforcement as well, to just try and really highlight there's a real lack of clarity, and we're all grappling with that same challenge. So thank you so much, Wallace, for taking time out of your day to walk us through all of those issues today. And it's been really interesting hearing your thoughts on things that might be changing under the Trump administration. And thank you, everybody, also for joining the webinar today, and hope you have a good rest of your day. Goodbye.
Thank you.
Goodbye.